What if the jury clears you of the most serious charges, but then the judge still uses those same accusations to send you to prison? That sounds illegal, but it isn't. And right now, that question sits at the center of the Sean Diddy Combs appeal. Not whether he was convicted, he was, but whether the judge punished him for things a jury rejected. This is Crime News Cross-Examined. Here's what actually happened. A federal jury heard weeks of testimony about Sean Combs' private relationships, power dynamics, and alleged misconduct. The verdict was split. The jury acquitted him of the most serious charges, racketeering conspiracy and sex trafficking. But they convicted him on 2 Mann Act counts involving transportation for prostitution. Then came sentencing. The judge imposed 50 months in federal prison and a significant fine. And this is where the case stops becoming about guilt and starts becoming about power. Because in explaining the sentence, the court relied heavily on conduct tied to the very allegations the jury rejected. That tension is now the core of the appeal. From the government's perspective, this is simple. Sentencing is not a retrial. Judges are allowed, even expected, to look at the full picture of a defendant's behavior when deciding punishment. And that includes conduct surrounding the offense, patterns of control, and risk to others, even if those facts did not lead to a conviction. In the prosecution's view, the jury did not say the behavior never happened. They said it wasn't proven beyond a reasonable doubt, and sentencing does not use that standard. So, to the government, the judge didn't ignore the jury. The judge contextualized it. The defense sees something far more dangerous. They argue that the sentence only makes sense if the court treated acquitted allegations as true. And if that's allowed, then not guilty becomes a technicality, not a protection. And their point is simple, but powerful. If a jury rejects the most serious allegations, the court should not be able to quietly reinsert them under a lower standard and call it sentencing. Otherwise, the jury becomes ceremonial, a suggestion, not a safeguard. Now let's turn to the cross-examination. This is where the contradiction snaps into focus. If a judge can increase punishment based on facts the jury rejected, then who actually decides guilt? Why demand proof beyond a reasonable doubt if punishment can be based on probably? That's not a procedural quirk, it's a philosophical conflict. The system says juries are the backbone of justice, but the practice, in this case and many more, treats them like a speed bump. And once you see that, it's hard to unsee. And now let's examine the law. For years, federal courts allowed this through the concept of relevant conduct. But that foundation is cracking. In 2024, the U.S. Sentencing Commission amended the federal guidelines to exclude acquitted conduct from guidance calculations. That's not symbolic, it's a statement. It says punishment should not be built on facts a jury rejected. Judges still have discretion, yes, but the system is clearly backing away from the idea that acquitted conduct can quietly inflate sentences. This case sits right at that fault line. Let's turn to my ruling. Here's where I land. Even if technically permitted, punishing someone for acquitted conduct is fundamentally unfair. It drains the meaning from jury verdicts, it lowers the burden of proof after the fact, and it erodes trust in the justice system. Courts, yes, may continue to allow it for now, but the direction of the law is clear. When a jury says not guilty, that has to mean something. If it doesn't, then the verdict is just theater. If you want legal analysis without the noise, subscribe and tell me this. Should a judge ever be allowed to punish someone for a crime the jury rejected? And for more detailed coverage of this case and hundreds more, visit CrimesDigest.com. And always remember, the truth matters, and so does reasonable doubt. See you in the next case.